Yes, thanks. I'm also going to be representing some comments made by Dr. Grant Orvis, who's not here today, but I believe he's on the executive committee. So if I could at least get another minute, that would be awesome. Before I start, I just would like to ask how many hemp farmers are actually here today? Can I just see a raise of hands? Okay, awesome, thanks. So my name is Veronica Carpio. I'm with Grow Hemp Colorado. First, I want to start off saying that I believe that there's a huge lack of representation, which by farmers in Colorado who will be directly affected by what Colorado is about to submit to USDA and by USDA interim rules. So I would encourage our state people involved in this whole submission to please don't let lobbyists, lawyers, and those who have zero real-time experience in the field to represent our voice or be the main voice for Colorado hemp farmers, the CDA, governor, or the USDA. Moving on, I would like to get to DEA. DEA, as mentioned here today, is not really our friend. They've never been a friend of cannabis or industrial hemp. They've already proven to be difficult to work with communication-wise for testing labs for USDA for other states. I'm very concerned there's a heightened possibility they can create further criminal offenses for non-compliant crops. And producers can be raided, property can be seized, and huge legal fees can be incurred. I've been raided before by the federal government with the assistance of local law enforcement, and I would never wish that on my worst enemy. So I would ask the state to push back against DEA dictating demands on the industry. History has also shown that DEA's targeting of tribal members has been a problem in the past for industrial hemp. They even went as far as coming onto tribal property without permission, suing tribal members for violation of the Controlled Substance Act, which ended up in a lifetime ban on growing hemp. So again, I would encourage us to push back against DEA influence, both here in the state and on tribal land here in Colorado. I also feel that the state plan should not include or dictate it to any of the tribes here in Colorado without their full consent and engagement. Unfortunately, I haven't seen a lot of engagement through the CHAMPS program, which I could be wrong, with tribes, and they are part of this situation, and it would be unfair for us to submit a plan that dictates also to them without their direct involvement. Moving on to law enforcement. There was some discussion about this in the beginning. For clarification, it says law enforcement must collect and dispose of non-compliant hemp, anything over 0.3. When I was talking to law enforcement people I know, they were asking me, how do we actually go collect? Do we get on a combine and get into a field, and do we need semi-trailers to come take this? Where do we dispose that 40 tons of hemp? This requirement for law enforcement is overburdensome, not necessary. There's no public safety concern that would justify this mandate. I believe probably most of us in this room would say that sampling, testing, and destruction shall be left in the hands of the state ag department. That's what we've done for all these years. We've shown that our ag department is more than capable of managing us. Moving on to exemption for felons. Clarification that it's just drug felons. I've had some discussions with CDA about this. I am a drug felon. I was operating here under the state since the very inception of industrial hemp, and I would ask that there's no probationary factor. I've been told that I might be on probation again, so I can grow industrial hemp. So figuring out what to do with people like me, I would just say follow the exemption that was fought for at the federal level. I would also encourage the state to be more restrictive on felons. So murderers, rapists, child molesters, they're all okay, but drug felons like myself are not. So, thank you. So that's what I would encourage us to be more restrictive. Exemptions for destruction. Dwayne had mentioned this. In the CSA, it's always been defined, marijuana has always been defined with exemptions, the stock and the seed. I believe that our state should adopt the same exemptions. If a non-compliant crop is determined not to be hemp anymore and it's under marijuana, the DEA's own definition of marijuana excludes stock and seed. So if the resin-producing parts of the plant have to be destroyed, so be it, but at least the stock and the seed, non-viable seed in the end, should be exempted from destruction thus kind of damage controlling full loss of the farmers, and this would be a voluntary basis, but something that even their own DEA verbiage excludes under the definition of marijuana. So we should adopt that. Testing samples. I'm not sure how many people have actually read the testing protocol that has been listed on the USDA site, but there specifically it says samples are to be dried to a consistent loss. This is talking about moisture, typically between 5 and 12% moisture content. Anyone in this industry who's taken samples to the lab knows that if it's dry at 5% or 12%, it could have definitely a difference in cannabinoid content. So having a range between 5 and 12% is not going to be an accurate measurement. So I think CDA has been doing 0 to 5% or 0% moisture content, and I would encourage us to stick with that, what we've been doing, because what we do has been working.
1 minute, Brooke.
Okay. I would ask for a testing exemption for AOSCA certified genetics, which have been proven stable for 3 or more years in more than one state. This exemption for testing would lessen expenses for farmers, encourage use of certified seed, stable genetics, and less burden on testing with the state. One of the corrective plans we should consider is including a ban of certain seed genetics, full seed and clones, once they have tested over 0.3 more than 3 times in 12 months. Bad genetics have been a continual source of harm to farmers with 0 repercussions and consequences thus far. So if something continues to show hot, part of our corrective plan as a state should be to ban those genetics, which we have not done this far. I do support 100% testing of the fields. Part of some of the bad actors in this industry have been getting away with years because they know CDA is not going to come test them. So I do support 100% testing and whatever CDA needs for that support. My last comment really is 2 things. One, suggestions that have been made here in the past and in the future that Colorado can somehow overrule USDA interim rules through state regulation, legislation, and statute is really misleading, especially because those people supported the Farm Bill and now they're arguing against it. Finally, I conclude by saying this doesn't really have to do with state submission, but any testing lab in Colorado that is going to test hemp, whether it's state or third party, we really need to push that there's standardization in testing, because anyone who's taken a hemp test, and if it's the same sample, we take it to 2 or 3 different labs, including CDA, we have 3 to 4 different test results off the same material. So I encourage us to have testing standards, not necessarily as part of our submission, but just in general. So thank you for your time and thank you for your hard work.